Hello everyone, today I'll be presenting on the topic Prevention of Money Laundering Act 2002. Let's get started. So, the chapter 2 of this act discusses about the offense of money laundering. So, a person is guilty of money laundering if they are directly or indirectly participating in, assisting in, or involved in any activity related to handling money or property gained from illegal activities. This includes concealment, possession, acquisition, use, or projecting as untainted property or claiming as untainted property. Moving forward, money laundering is not a one-time crime. It continues as long as the person is hiding, using, or enjoying the money even after years of crime. So a person will be imprisoned for 3 to 7 years, and in case of serious crime, he will be imprisoned for a maximum of 10 years under this act. And additional monetary penalties will also be imposed. Moving forward, key objectives of this act. Transparency in financial systems, that is, to reduce the risk of misuse of funds. Next objective is prevent and control money laundering, that is, to stop the conversion of illegal obtained assets into legitimate assets. Next thing would be confiscation of assets, that is, identifying and freezing the property which is believed to be involved in the crime. Next thing would be establishing accountability, that means to ensure that the financial institutions maintain records and report suspicious transactions. Moving on, what is attachment of property? Attachment of the property refers to the legal process where the property is believed to be involved in money laundering activities and is seized or restrained so that the person cannot dispose of or transfer such property. So, who can attach a property? The director or any officer not below the rank of deputy director, and the property can be attached for a period not exceeding 180 days from the date of order, and within a period from 30 days of such attachment he shall file a complaint stating facts of such attachment to adjudicating authority. Other than that, all the relevant materials and a copy of order should be sent in a sealed envelope to the adjudicating authority. Moving on, the adjudication process. The adjudicating authority may serve a 30-day notice to the accused person. The notice asks the accused person to explain the source of income or assets linked to the property attached, seized, or frozen, provide evidence supporting their claim, and justify why the property should not be declared as proceeds of crime. And in case of property being jointly owned, all such persons will be served a notice. And in case the property is finalized to be a proceeds of crime, then the property will be confiscated by the central government, and the central government will appoint an administrator to manage, receive, and dispose of such property. Moving forward, vesting of property in the central government. When the property is confiscated under certain legal provisions, it automatically becomes the property of central government with no debts or claims attached. If someone else claims an interest in the property, such as lease or loan, the court or authority will listen to that person. If it finds that interest was created just to avoid the law, they can declare the claim as invalid, and the property will go to central government without any claims. However, if the claim, such as lease or loan, is found to be invalid, the person who created it can be sued for damages by the affected party. Moving on, reporting entity to maintain records. So, a reporting entity is basically any financial institution or banking companies. So, they are required to maintain transaction records, report certain transactions, maintain client identity records. So, for how long they must keep these records? So, the transaction records must be maintained for 5 years from the date of such transaction. Client identity records and account records must be maintained for 5 years after the account is closed or the business relationship ends, whichever comes later. Moving on. Enhance due diligence. Where a client is undertaking specified transactions, verify the identity of such clients, take additional steps to examine ownership, financial position, source of funds, take additional steps to record purpose of financial transaction, nature of relationship between the parties, maintain all the records for 5 years from the date of such transaction. So what is a specified transaction? Cash withdrawal or deposit exceeding certain limit, forex transactions exceeding certain limit, high value of imports or remittances, or any other transactions that is believed to be involved in money laundering. So, if all of these points are not considered, then the client cannot continue with such specified transaction. Power of director to make inquiry and impose fines. So director on his own or by application by any person with respect to whether the reporting entity is maintaining and fulfilling its obligations with respect to maintaining client records. So in case there is any complexities found by the director, he may ask the reporting entity to get its accounts audited by the CA, and the expense of such auditing process will be borne by central government. If director finds any non-compliance, he may issue warnings, ask them to comply with certain instruction, ask them to send reports on measures being taken, and impose fine, that is rupees 10,000 to 1 lakh. Moving forward, Appellate Tribunal. Who can appeal? The director or any person aggrieved by the order of adjudicating authority or reporting entity aggrieved by the order of director. So, the said people should appeal within 45 days from the receipt of order, and decision is taken by majority. Moving on, offence under this act is cognizable and non-bailable. Cognizable is basically where the inspector can arrest a person without any warrants from the court. So, no person accused under this act shall be released or on bail or on his own bond unless public prosecutor has been given an opportunity to oppose the application for release, and where public prosecutor opposes such application, court is satisfied that he is not guilty of such offence and that he is not likely to commit offence while on bail, provided the following people may be released on bail if special court so directs. So the first one is to be the person below the age of 16, a woman, or sick or infirm people, or person accused of money laundering of sum less than 1 crore. Moving on to reciprocal arrangement. But before explaining what is reciprocal arrangement, I would like to explain few terms. So, corresponding law. A law of foreign country dealing with offence corresponding to any schedule offences. Offence of cross-border implication. Any conduct at a place outside India which would have been constituted as scheduled offence if it had been committed in India, and proceeds of such conduct or part thereof is transferred to India, or scheduled offence conducted in India and proceeds of crime or part thereof is transferred or attempted to be transferred outside India. Next term would be contracting state. Contracting state is basically a country or a place outside India with whom arrangement is made by central government, that is like a treaty. Moving on to letter of request to contracting state. Application to be made by investigating officer to special court stating that evidence in relation to investigation may be available in contracting state. So, the special court, after being satisfied, may issue letter of request to competent authority of contracting state to examine the facts and circumstances, take steps as specified by special court in letter of request, forward the evidence to special court. Moving on to reciprocal arrangement for process and assistance of transfer of accused person from India to contracting state. So, special court desires that summons accused person or other person or warrants for arrest or search issued by it shall be served in contracting state. Special court shall send duplicate of such summons or warrants to court or judge via notified authority, and such court or judge shall cause the same to be executed. Moving on to fine and penalty under this Act. So, punishment for vexatious search. If any authority or officer in exercise of power under this Act or rules, without any reason recorded in writing, searches any building or place or detains, searches, arrests any person, for every such offence, imprisonment up to 2 years or fine up to 50,000 or both. Fine and penalty in case of false information or failure to give information. In case of false information, any person willfully or maliciously giving false information and causing search or arrest to be made is jailed for 2 years, or a fine is imposed of 50,000 or both. So a person who is legally bound to answer refuses to answer, legally bound to sign but refuse to sign, or required to produce certain documents but omits such production, a fine of rupees 500 to 10,000 for each such default, or and an opportunity of being heard is given to such accused person. Moving on to offences by companies, where person committing contravention is a company. So, if a company breaks the law, both the company and person in charge of and responsible for its business at the time will be considered as guilty and can be punished. However, such a person is not punished if they can prove either they didn't know about the offense or they tried their best to prevent it. So, when it is proved the contravention has taken place, if the offence happened with the consent because of the connivance or due to neglect of any director, manager, company secretary or officer, then that person will also be considered guilty and punished. Thank you.